Welcome back, future criminologists. In this video, I will be discussing the parole evidence rule and its applicability. Before I discuss what is the parole evidence rule, I will discuss first what is parole evidence. Parole evidence. Parole evidence is any evidence 𝐂𝐤𝐤𝐷 or extrinsic evidence which is intended or tends to vary or contradict a complete and enforceable agreement embodied in a document. It may refer to testimonial, real, or documentary evidence. What does 𝐂𝐤𝐤𝐷 means? 𝐂𝐤𝐤𝐷 means from another place or outside source. Now we go to parole evidence rule. The parole evidence rule, on the other hand, is a rule in evidence which states that when the terms of an agreement have been reduced to writing, it is considered as containing all the terms agreed upon, and there can be, between the parties and their successors in interest, no evidence of such terms other than the contents of the written agreement. The parole evidence rule is stated in the negative. That is, when the agreement of parties was reduced in writing, there is no other evidence to prove the contents or the agreement of the parties other than the written agreement itself. Take note of this. Parole evidence is evidence outside of the agreement of the parties, while the parole evidence rule prevents the presentation of such parole evidence. Requisites for the application of the parole evidence rule. 1. There must be a valid contract. 2. The terms of the agreement must be reduced to writing. The word agreement includes wills. 3. The dispute is between the parties or their successors in interest. 4. There is dispute as to the terms of the agreement. Take note that the parole evidence rule does not apply and may not be properly invoked by either party to the litigation against the other, where at least one party to the suit is not a party or privy to the written agreement in question, and does not base a claim or assert a right originating in the instrument of the relation established thereby. Thus, if one of the parties to the case is a complete stranger to the contract involved therein, he is not bound by this rule and can introduce extrinsic evidence against the efficacy of the writing. Always remember that most of the time, in every rule or general rule, there is an exemption. Now we go to the exemptions to the parole evidence rule. A party may present evidence to modify, explain, or add to the terms of the written agreement if he puts in issue in his pleadings the following. 1. Failure of the written agreement to express the true intent of the parties thereto. Halimbawa, si Juan at Jose nagkasundo na ang sasakyan ni Juan ay rerentahan lang ni Jose buwan-buwan at pagkatapos ibabalik din ni Jose. Kaso ang nailagay pala sa kasulatan ay si Juan binibenta niya ang sasakyan kay Jose at ang buwanang bayad ay paunang bayad sa sasakyan. In this case, parole evidence then becomes competent and admissible to prove that the instrument was in truth and in fact one of that of Alice. 2. Intrinsic ambiguity, mistake, or imperfection in the written agreement. We will discuss this further later. 3. Validity of the written agreement. Halimbawa, wala talaga silang pinagkasunduan. 4. Existence of another terms agreed to by the parties or their successors in interest after the execution of the written agreement. What do we mean by mistake in number 2? The mistake contemplated is one which is a mistake of fact, mutual to both parties. Now we go to the ambiguity stated in number 2. Ambiguity refers to an uncertainty or doubt in the document or something in its provisions is not clear, or of being susceptible to various interpretations or meaning. There are 3 kinds of ambiguities. 1. Intrinsic or latent ambiguity. 2. Extrinsic or patent ambiguity. 3. Intermediate ambiguity. Intrinsic or latent ambiguity. On its face, the writing appears clear and unambiguous, but there are collateral matters which make the meaning uncertain. It is curable by evidence aliende. Intrinsic or latent ambiguity is further subdivided in 2 parts. 1. When the description of the person or property is clear, but it turns out the description fits 2 or more persons or things. For example, the donee is described as my Aunt Jane, but the donor has several aunts named Jane. 2. When the description of the person or object is imperfect or erroneous so as to leave doubt what person or object is referred to. For example, the money shall be for the tuition fee of my son who is enrolled in UST, but it is the daughter who is enrolled in UST, while the son is enrolled in San Beda. Reason for the exception of intrinsic ambiguity to the parole evidence rule. The introduction of oral testimony does not vary or contradict the document, but it aids the court in ascertaining and interpreting the document, thereby enabling it to give effect and life to the document. Extrinsic or patent ambiguity. It is where the ambiguity is apparent on the face of the writing and requires that something be added to make the meaning certain. It cannot be cured by evidence aliende because it is only intrinsic ambiguity, not extrinsic ambiguity, which serves as an exemption to the parole evidence rule. Thus, no amount of evidence will clear the ambiguity. Intermediate ambiguity. It is where the ambiguity consists in the use of equivocal words, susceptible of 2 or more interpretation. It is curable by evidence aliende. Parole evidence is admissible to ascertain which sense or meaning or interpretation was intended by the parties. For example, the written agreement stated that the currency that shall be used in paying is dollar. So what dollar are you referring to? To end, please subscribe to our channel and stay tuned for more videos.